Tragic story of a little 20-month-old boy named Quentin Simon.
This is a missing persons case that feels so different.
Where is the baby?
Our search teams at the waste management landfill found what they believed were human remains.
Leilani Simon is charged with the murder of her 20-month-old son.
I look over and check on my kids, and he was gone.
The toddler in landfill murder trial. Trial coverage today on Court TV.
All right, good morning, everyone. Let me get myself set up here. While I'm doing that, would you please bring out Ms. Simon? With that, we're on the record for SPCR 22-326J6, the state of Georgia versus Leilani Simon. Let the record reflect that Simon is present with her counsel, Greg Hilliard and Robert Hurst. The state is represented by USA Tim Dean and Jenny Parker and Detective Lynn. So, in getting started this morning, is there anything that we need to pick up before we bring in the jury?
Only the insurance case. I'm not sure whether we try to put we have two I don't think it'll then our next so unfortunately we can't take these witnesses and fairly long. But if we can get witnesses in
Leilani with those clear.
No, because Mr. Dean told me that, and I understand how the schedule is up there. So. Hold on, I do have to do one thing. Let me put on my microphone. Can you hear me? Okay, good. Mr. Dean told me that, and I understand. And I've had to deal with Dr. Dare so I know getting her schedule because she took off is hard. So I'm fine with doing these two witnesses.
Thank you, Smith. And ladies and gentlemen, welcome back. Please have a seat. Good morning. So we're going to launch right into testimony this morning. We are probably going to have an earlier than usual lunch and probably a little bit longer period of time. But that's just a matter of written scheduling, and that happens often in a trial. So just to give you that heads up, but now the question, have you all been able to comply with the court's instructions? Have you avoided conversations and discussions about this case? Have any of you been exposed to TV stories, internet stories, any media in any shape or form? Thank you very much. Statement call next witness.
Sherry Fentress.
Good morning. Good morning.
You're here because you
Yes, that's correct.
please introduce yourself.
Yes, my name is Sherry Fentress. The first name is spelled Sherri. Last name spelled Fentress.
What is your profession?
I'm a biologist forensic examiner for the FBI Laboratory DNA Casework Unit in Quantico, Virginia.
How long have you worked here?
I've worked there for about 14 years.
What is your work system?
As a biologist forensic examiner, I perform primarily work on missing persons and unidentified remains cases, in addition to some other criminal casework. As an examiner, I will receive case information and determine what pieces of evidence need to be tested based on that information. I'll determine what the best course of testing is for those items, and then I am the one who will coordinate the movement of the evidence through the laboratory, directing the work of biologists along the way, and making key decisions at the points in the testing. Okay.
in the case of training, experience, and passion. It does really.
Yes, I received a Bachelor of Science in Animal Science with concentration in agriculture biotechnology and minors in biology and chemistry from the University of Delaware. And then I went on to receive my Master of Science in Criminal Justice, specializing in forensic science from Michigan State University. In order to be an examiner, I went through training by about 2.5 years. It consists of practical laboratory exercises and oral boards, as well as moot boards, in order to make sure that not only do I understand the fundamentals behind what I'm testing, but also that I can express it in a clear manner for you. Based on, my experience, in addition to working for the FBI laboratory, spans about 10 years prior to that. I worked for the Armed Forces DNA Identification Laboratory as a graduate intern. I worked for a private laboratory also, and then for 5.5 years prior to working for the FBI laboratory, I worked for the state of Delaware.
Can you testify as
Yes, I have. I testified in federal and state courts. Yes, I have. Okay, and Your Honor, just to clarify, it's not Dr. Fentress. I have a master's, but not a PhD.
I just figured. Okay. Were you asked if you could something? In this case.
Yes, and a kinship analysis is just an evaluation of relatedness between individuals.
Then what did you see?
In this case, I received a number of bone and tissue specimens. We would term those questioned items because we do not know where they came from or the individual that they came from. And I received reference samples from 3 individuals, Billy Joe Howe, Henry Moss Jr., and Leilani Simon, to compare to these unidentified remains.
And what is it you're trying to figure out? As simply as you can.
In a kinship analysis, I'm just testing to see whether the relationship that's proposed could be supported by the comparison of the profiles that I obtained from the evidence. So in this case, I want to see if the unidentified remains could be the child of Leilani Simon and Henry.
And how do you go with that?
So in order to conduct that, we first need to test the items to recover DNA from them, and that involves a sequence of steps in the laboratory. We first take a small cutting or sampling from each of the items. We then will isolate the DNA, and then in the next step, we determine about how much DNA we were able to recover in that first step. And based on that, we can optimize the remaining steps where we do amplification, which is where you make millions of copies of targeted regions of the DNA. And then the final step where we determine exactly what is the profile of each of those locations. And just to clarify a little further for the DNA casework unit, we look at 21 different locations that are expected to be different between individuals with the exception of identical twins, in addition to 3 locations that will provide information as to whether the individual provided the DNA is male or female.
Now, was the technique you used in this case, is that something?
Yes, it's something that can be tested for validity, yes.
And has it been subject to peer review?
Yes, it has.
Are there standards controlling?
Yes, there are standards called the quality assurance standards that are issued by the FBI that define everything from what personnel qualifications are required, down to handling the evidence and what types of laboratory procedures should be performed for each type of evidence.
It has attracted widespread relevance.
Yes, it has.
When you conduct a comparison, how do you rate your ultimate result?
So when I conduct that kinship comparison, like I said, I'm comparing the product profiles against each other. So what I would say is that based on the comparison of the DNA profiles, the results are however many times more likely if the individuals are related as stated than if they are not.
And I'd like to draw your attention specifically to you see it in the
It's 2 pages.
Now, these are bones that have already been examined.
Yes, that is correct.
And we've heard testimony. What are the images? What are those from?
The images that I'm looking at are 2 of the bones that I tested. I can tell that they are, am I allowed to pull up the?
Well,
Okay. I can tell that they are bones that I tested because they are laboratory number 2022-02600, the item numbers 29-1 and 30-1. And I recommend pictures from my cases.
Is it fairly inaccurate if these bones that you're
Yes, that is correct.
Okay. Now, can you, I don't want to put this on the screen, but can you hold that off very quickly?
Yes, so if you can see, this is the item 29-1 bone. If you see there's a square taken out of the center here, that was the cutting that we took in order to do the processing. And then on the next page, this is a little harder to see, but it's item 30-1. And it is a small bone right there in the center. Because of the size of the bone, we had to use the entire bone for this sample. So there's no specific cut area that you will see. That's correct.
You were able to take these 2 bones and develop a DNA profile.
That is correct, yes.
And you were able to compare that to DNA samples.
Yes, that is correct.
And you were able to come up with conclusions.
Yes, I was able to develop a likelihood ratio, explaining how much support there is for the relation. Yes.
And what was your conclusion?
Your Honor, may I refer to my report to state the conclusion? Starting with the item 29-1 bone, based on the STR results and the comparison of item 29-1 to Moss Jr. and L. Simon, the combined kinship index is approximately 4.1 quintillion. Therefore, the DNA profile obtained from item 29-1 is approximately 4.1 quintillion times more likely if item 29-1 is from the son of Moss Jr. and L. Simon, than if item 29-1 is from someone unrelated to these individuals. And these results provide strong evidence that item 29-1 originated from Quentin Simon.
That's the next
And for this one, based on the STR typing results, the DNA profile obtained from item 30-1 is approximately 12 quintillion times more likely if item 30-1 is from son of Moss Jr. and L. Simon than if item 30-1 is from someone unrelated to these individuals. And these results also provide strong evidence that item 30-1 originated from Quinton Simon. One vote, please.
No further questions.
Any cross?
I did good. Morning, inspectors. How are you?
Good morning, President Simon.
I don't get people like you on cross-examination very often, so I'm going to have a bunch of questions for you. So I don't know if it passed. Okay. So let's start. Kinship analysis is, are you looking at alleles or genes or DNA? I mean, I don't understand the difference between the two.
Sure. So allele, genes, and DNA are all related to DNA. When I say that I'm looking at different locations and I'm looking at the profile of those different locations, that would be where I'm referring to alleles. So to take a quick step back, when we look at the nuclear DNA, we're looking at what are called short tandem repeats. And those are short patterns of DNA that are repeated back to back. And that number of repeats may differ between individuals at any given location. And it can also differ between locations within an individual. So as I mentioned, we look at 21 different locations. What I had yet to say is that we receive half of our DNA from our mom and half from our dad. So at each of those locations, you would expect to see no more than 2 of those numbers. So for example, if at one location I'm a 15-17, it means that I received a 15 from one parent and a 17 from the other. So you're going to expect to see 1 or 2 numbers at each of those locations. Now, when I do my comparisons, where I'm looking at that unidentified profile compared to the potential parents' profiles, what I'm looking for is that pattern. Do I see 1 number for each parent at each of the locations in that questioned or unknown item? And if I see support for that, then I will go on and perform that kinship calculation for the statistic that I mentioned, that 4.1 quintillion or that 12 quintillion.
The reason why I asked that is kind of me nerding out a little bit. When you're doing the DNA, I mean, DNA is an amazing structure. Okay? But basically what you're doing is looking at how many, let's just say, a random piece of DNA from any person, how many different, I guess you would call it, locations are there on that strand of DNA?
So there's a large number of different locations on that strand of DNA. And actually, to clarify further, most of our DNA is actually going to be the same. That's what makes us human. It's a very small percentage, less than 1%, that will differ between individuals. Again, that's with the exception of identical twins. So we, in our laboratory, target 21 of those locations.
How many locations are there?
I can't remember off the top of my head exactly how
Thousands, millions.
Thousands, I don't remember exactly.
So, but you target these 21 particular locations and these other 3 locations. So you narrow your analysis down to basically 24 something, right?
This is correct, yes.
And I'm curious because, again, it's a weird thing to me. The bones you tested, one was 4 quintillion times more likely to be related. And the same bone tested differently was 12 quintillion to be related. What accounts for that statistical discrepancy?
So those were 2 different bones that were tested. When we obtain a DNA profile, I would say a common misconception is that if you obtain a DNA profile, you just got DNA and that's all that matters. But really, that profile can range anywhere from one of those locations all the way up to the entire profile that we're targeting. The fewer locations you have, the lower that number is going to be when you have a calculation. So for the first bone, I was able to get 20 of the 21 locations for comparison to that. And for the second bone, I was able to get all 21 locations. So that's where you get a slight difference in numbers.
I was just curious. I'm fascinated too by the actual manner of method. Obviously, you would take a bone, and I guess you would. What would you do with the bone once you get it?
So once we get it, we want to make sure that the bone is clean on the outside. So we do some washing of the bone. We will then sand the area that we're using, that we're going to cut with what's a Dremel tool. If any of you are familiar with that. And then we will take a cutting again with the Dremel tool of that small section that we're going to be testing. We then use something called a freezer mill that freezes the bone, and then it uses a magnet to crush it into a fine powder. And then that powder is what we will then apply the chemicals to in order to isolate the DNA.
And then when you take the DNA and you test that, how do you get your statistical analysis from the test?
So once we test the DNA and obtain that profile, again, I'll do that visual comparison first. If in that visual comparison, I didn't see evidence of a parental-child relationship, I would say that was an exclusion, meaning those remains could not have come from a child of the two individuals. Because I saw that pattern, I then took those profiles and I uploaded them into a kinship calculation software. And what that software does is it analyzes the proposed relationship, and based on the population frequencies, or how often we see these different profiles in the population, it provides that statistic for how likely those profiles are if the individuals are related.
My profile, I won't put words in your mouth, but my understanding is it shows these different genes or genetic factors. How does it display that? Is it letters, numbers? How does it
So that profile in our case notes will be in the form of a table. So in that table, each of the locations is listed, and for each of the locations where a profile was able to be obtained, you'll see the number. So for example, first location D3, you might see that 1517. At another location, maybe FGA is another location. It may say 22, meaning 22 was received from mom and 22 was received from dad. So again, you'll have that table with each location, and next to it, the set of numbers associated with that location. And that comprises the file for the individual.
And just out of curiosity, you said that when you're going through your bona fides to do this, how old are you again? I'm not trying to pry, but I was just curious. How old are you?
I'm 45.
And you got your Bachelor of Science from the University of Delaware, correct?
Yes, that's correct.
And you got your Master's of Science in Criminal Justice. I didn't write that. So which university was that?
That was from Michigan State University.
How long was the Master's on it?
I would say 2 to 3 years.
So I assume the Bachelor's was a normal 4-year degree.
That's correct.
And 2 to 3 years for your Master's, correct?
Yes, that's correct.
And then on top of that, you went to extra training at the FBI from about 2.5 years, I think is what you said, 2.5 years?
Yes, as an examiner. Yes.
And part of that was is they trained you how to present this testimony ethics in court to be explained to normal people like me, correct?
Yes, that's correct.
And of course, how to do the job itself, right?
Yes.
And how long have you been an examiner at the FBI?
I've been an examiner at the FBI for 10 years now. Prior to that, I was a biologist.
And how long were you a biologist?
I was a biologist for about 4 years. And to remind you of the difference, biologist does the laboratory processing, and an examiner will coordinate that processing.
And as an examiner, you basically, what you just described, test the numbers, you translate that to, I guess, the result of the test.
So as an examiner, I would assign the testing strategy for the bones. I would coordinate the testing. If there's any questions, the biologist will come to me. If there's any questions about how to proceed, there are several steps along the way where I have to make the decision as to how to proceed. And then once data is produced, I analyze that data, I generate a report with conclusions, and I'm the one who is able to testify to those conclusions.
Ms. Fisher, thank you so much. I appreciate it. And it's been so informative.
May this witness speak.
Yes, sir.
Thank you, ma'am. Thank you. Thank you for listening to me. Yes, sir.
Cynthia Morris.
Good morning.
Wait, could you please introduce yourself and very spelling your first and last?
Sure. My name is Dr. Cynthia Lynn Morris Kukowski. That's Cynthia. Last name is MORRIS hyphen KUKOSKI.
And you're here today to
Yes, I did.
where do you work?
I work at the FBI laboratory in the chemistry unit.
And what's your official title?
I'm a forensic examiner toxicologist for the chemistry unit.
And how long have you been in that position?
I've been in the position for over 20 years.
And what sort of things?
As a toxicologist, we work on biological evidence, things as blood, urine, vitreous, vomit, tissues, and sometimes foods and other stains.
I'd like to ask you some questions about education training experience.
Okay.
Let's start with education. Can you tell us about what education you have?
Sure. I have a bachelor's of science in pharmacy from the Massachusetts College of Pharmacy. I have a doctor of pharmacy from the Massachusetts College of Pharmacy, clinical residency in clinical toxicology from Hennepin Regional Poison Center.
And what about training?
At the FBI laboratory, we undertook a 2-year extensive forensic examiner training. It breaks down into both written didactic tests in various subjects, as well as competency tests on various items of evidence in various exams, as well as moot courts.
In terms of experience, you said you've been working there for
Over 20 years.
Could you give any kind of a ballpark? This is forensic toxicology case work.
Because I couldn't even begin to.
How many zeros is that?
Yeah, that's an over exaggeration, but oh yeah, yeah.
Can you testify?
Yes, I have testified in various military tribunals as well as grand juries, state and federal cases.
And in those instances, have you been accepted by the court?
Yes, I have.
Can I have an offer? No, objection. I want to ask you some questions about your work. Did you perform some analysis in this case?
Yes, I have.
At some point, did your lab receive from the agents in Savannah here a pillowcase?
Yes, we did.
And were you asked to look at that to see whether it's suitable for forensic toxicology analysis?
Yes, I was asked to look at it.
And can you tell me what the results of your review of the pillowcase?
After visually looking at the pillow inside the pillowcase, I deemed it unsuitable for toxicology analysis.
meaning either the debris or stain that was on there was too small and just couldn't be analyzed.
Is it the case that you need, if you're trying to do forensic toxicology stain, or this, get all the
Yes, I've analyzed various stains over the years, be it urine stains from someone peeing their pants, vomit stains from being over an item after someone's had too much to drink, as well as blood stains that may or may not be sweat stains. And basically doing this over 20 years and putting samples, putting some solution on various types of clothing or other household items, we look at the amount of volume that it takes for the particular procedure, and then by putting that on objects, I've pretty much gotten to the point where I can tell you that for most items, I need to cut a 2 inch by 2 inch square piece of material with a stain on it.
And your assessment was
correct. There's nothing.
Did you also receive something that appeared to be great?
Yes.
How did you know this?
I went down to talk with the forensic anthropologist after I worked with my chemist to check in the clothing and articles from the house and asked her what she received in the case. And she had said that she found and had some debris that I might be interested in that was found within the frontal bone. And I've worked with brain specimens over 20 years, as well as other tissues and organs. And it actually has a very unique smell that you cannot miss.
Now, the forensic anthropologist,
that was Dr. Christensen.
I'd like to know first of what's been admitted and evidence. Images from Dr. Christensen. Yeah, I'd like to see indicate right here on the third page. It's basically what this
It's this mass right here. And this was received, Dr. Christensen did a hand transfer. This was inside a Ziploc bag, which was inside a paper bag. And then I took it up and put it in the refrigerator, just storage overnight, had my chemist check it in the next day, and physically put on all of the flavors that were there with the tissue.
Just for the record, you indicated towards the dark mass in the top center of page 3.
Correct.
Now, did you conduct a drug screen on that piece of brain tissue to see whether you could?
Yes, I did.
What is it?
Metabolite is a substance that forms when the body is breaking down a particular drug. In this case, when cocaine is broken down by the body, it forms 2 metabolites. Okay, ethylene, if you were using or taking cocaine in conjunction with ethanol, and another metabolite, ethylene methyl ester. There is a third metabolite called benzoylecgonine, but benzoylecgonine doesn't require water. If I put cocaine in a glass of water, I could actually form benzoylecgonine.
You understand that?
Yes, sir.
I'll take care of it. Okay. You are really smart. So I'd like to just ask you to explain sort of specifically what the process was for conducting drug screening. What did you do?
First, you actually have, you take the specimen itself, you take a portion of that, you weigh it and you mix it 1-to-1 with deionized water and homogenate it, meaning you're going to grind it up and mix it together. You then have to weigh a small portion of that, which is 1 gram, and put that into a test tube. After you have that specimen ready, you're also going to take a negative control brain as well as 2 other samples of negative control brain that I'm going to spike at various levels that I actually recorded and know what they are. After I do that, I add a solution to all of the samples. It's called an internal standard that's there that has drugs with a similar properties of the drugs I'm looking for, but not the drugs themselves. And I do that to make sure that each specimen actually properly extracts through the procedure. If not, and if it doesn't come through, there's something wrong with that particular sample. All of those samples are processed, analyzed using the alkaline drug screen, which uses solid phase extraction, which is a cleanup method that is used to do away with the debris and the biological material and fats and things that we're not interested in. And it concentrates in these individual one-use cartridges as a filter in there. And it's filtering in all the stuff we don't want, all of that debris. And then we can concentrate with a solution all the stuff we do want, write it down, put that in a vial, and put that on an instrument called a liquid chromatography tandem spectrum.
Now, this technique you described evidently
Yes, solid phase extraction technique has been used for over 20 years. This procedure has been used at the FBI laboratory since 2006. These cartridges have been manufactured since 2005, has been used widely in the forensic toxicology community as well as in forensics itself. And the instrument is used not only in toxicology in our lab, but other divisions and also outside the lab.
All right. So after all that, what was this whether this brain that you
I did not detect any.
negative?
Not detect.
No further questions. Yes.
Dr. Kukowski, right?
Morris Kukowski.
Morris Kukowski. I'm going to jump back a little bit. Forensic toxicology analysis. Do you only test for what you're asked to test for, or do you test for any type of toxicity?
Depends on the request.
Let's talk about this particular request. Okay, were you asked to test for any metabolites of controlled substances, or specifically cocaine?
No, we're actually specifically asked to look for cocaine metabolites, methamphetamine metabolite, fentanyl metabolite, as well as oxycodone and oxycodone metabolite.
Okay, and Mr. Dean said that he asked about the cocaine. You said it wasn't detected, correct?
That is correct.
Okay. That seems different than not being present to me. I assume you use your words properly. So you said you didn't detect anything.
Correct. According to our lab policy, we either detect something or not. It's considered either not detected, detective, inconclusive, or it's just our terminology.
And did you have anything that was detected?
In the brain tissue?
In the brain tissue.
No.
And so, did you test for fentanyl?
Yes, it did.
Okay. Methamphetamine?
Yes.
Okay. Percocets? Oxycodone? I guess oxycodone is another name for Percocet. I'm not saying. You corrected me. So.
Oh, sorry. Percocet actually is a combination medicine, oxycodone and acetaminophen. In this, I was not looking for the acetaminophen part.
And you said that, and I'm curious. So when you take the tissue, I didn't understand anything of what you just said. So,
okay.
So let's assume you're talking to somebody who has a much smaller brain than you. What exactly does the testing usually include?
The testing includes you analyzing the sample with a negative control that has no known drug in it, the sample itself, and various positive controls.
And with regards to, you will tell us the biological tissue, will take it and you will process it. What's involved in the process?
That's a solid phase extraction where you're removing and filtering out all the stuff you're not interested in, and then concentrating the stuff that's left in that cartridge.
And how big of a sample are we talking?
It's a 1 gram, 1-to-1 emulsion. So 1 gram containing of 50-50 water and tissue sample.
So when you say 1 gram, I assume the total weight's 1 gram.
Correct.
So it's like half water and half tissue.
Correct.
I just don't understand, so I'm trying to make sure I'm not mistaken. And then I guess you'll put that in that big long word thing you were talking about, the mass
instrument.
The instrument. Oh, okay. And then what does that do? Does that use some sort of light, gas, or I don't know how that works. So how does the instrument actually work?
Okay. The instrument has pumps with fluid. The fluid then gets mixed and put through a column. The column then separates things out based on the chemical properties, and then goes to an instrument called a mass spectrometer that will actually tell you the mass of what drug you're looking for, and then will fragment it and look at the chemical fingerprint of that particular.
You say that. I guess is it some sort of light deal or some sort of chemical atomic weight deal? I mean, I don't understand.
It's the chemical formula. So you take the formula of cocaine and add oxygen, it will give you the mass.
So what is, I guess it's looking for that particular chemical property.
It's looking, yes, for that exact mass. And the exact retention time. So as I said, things come out in a column and get detected in order. And each one has their own time that they come out with their own molecular weight and their own.
And that being said, you said that there were certain standards, and I don't understand the standards, so I'm just asking, to either be classified as detected, not detected, or inconclusive.
Or identified, correct.
Or identified. So, and what are those standards? I didn't hear that. So, what are those standards, and how do they relate to this?
Okay, not detected means you analyze the specimen as you saw fit, you added an internal standard, which is that solution with very similar properties that was detected in your sample, and you do not see the compound of interest that's found. Detected means you tested it once and you may have seen something, but for some reason you either didn't have enough specimen or something happened, you couldn't repeat the test. Inconclusive means that you detected it, and when you tested that particular chemical and added that internal standard that has similar properties, if that particular compound did not come through, you could not see it, that's considered inconclusive, because like if you can't see something that's very similar in your analysis, you can't say that you potentially saw or did not see what you were looking for.
And just to draw a conclusion, so in this particular case, having the sample that you tested, all you got the result, and I assume it was not a very, I look at the picture. See, you can show me, I guess this was the item. That item. And so that was the item number 3. So that was the piece that was tested, and
The portion of it.
that portion. And with regards to that, I think that's all the questions I have, because I think you've explained everything to me, so it's not understandable. I'm trying to make clear. You weren't able to test the pillow or pillowcase, correct? You were able to get enough testing material for this, correct?
For what, sorry?
For the item 78 that I just showed you.
Yeah.
The brain tissue.
That's item 29.
It's, yes, item 29.
Yes, sir.
Okay. And Were you given any other samples to test, or were those only samples?
No, I was also given a washcloth, a shirt, the pillow that we talked about, pants, and a towel.
You performed the testing on those?
The pink washcloth was considered unsuitable for analysis. The towel was considered unsuitable for analysis. And I did test stains from the shirt and the pants.
And I'm just curious, when you said not detected, it means it just wasn't detected at the same, right?
Correct, and that's the question.
That's all the questions I got. Thank you so much.
So that's the last witness that right? So, ladies and gentlemen, it is 5 to 11, so this is going to be an early break. We're going to begin and resume at 1 o'clock. So I'm going to ask you to be back at 12:15. Again, do not discuss the case. Don't let anyone discuss the case with you. Don't watch any news. Don't do research. You know the drill, right? Have a good break. All right. Anything you need to deal with now? I don't think so either. All right. See you around 1 o'clock, ready to go. We're in recess. All right. Let the record reflect that Simon is present with our counsel, and that the attorneys for the state are present as well as Detective Clemens. Anything we need to take up before we bring in? Thank you. All right, very well. Please bring in your. Thank you very much, Ben. And good afternoon, ladies and gentlemen. Please have a seat. The day is beautiful. I'm glad you had an opportunity to experience a little bit of that. I want to ask, has everyone been able to comply with the court's instructions? No one has spoken with anyone about the case, discussed the case, or had any done any research. Okay, all right. Madam Parker, Ms. Parker.
Your Honor, the state will call our next witness, Dr. Derickson.
You have issues that you report during these issues.
Yes, sir.
Good afternoon.
Good afternoon. Can you tell the jury who you are and your phone? Absolutely. My name is Laura, Lora, Darrisaw, Darrisaw. I work for the Georgia Bureau of Investigation, the GBI.
What do you do with the GBI?
I'm a medical examiner at the GBI.
Can you tell the jury a little bit about the background?
Yes, ma'am. I received my Bachelor of Science degree in Electrical Engineering from Marquette University in Milwaukee, Wisconsin. I then received my medical doctorate degree from the Medical College of Wisconsin. Following that, I had 4 years of residency training in pathology at the hospitals of the Medical College of Wisconsin, which trained me to be a general pathologist. And then I did specialty training in pediatric pathology at Baylor College of Medicine in Houston, Texas. And I did a 2-year fellowship. And then I did 1 year of specialty training in forensic pathology. And I was at the GBI through the college.
How long have you been?
Since 2004. Yes.
The student tendered off theirs all as the witnesses involved.
And actually, I think it was 2002. I'm sorry. 2002.
2 years.
Yes.
Why didn't you do the jury?
of medical examiner are to examine people who have died in certain circumstances. Generally, the circumstances are that individuals died suddenly or has died from unnatural type events, such as traumatic events. And the purpose of the role of the medical examiner is to determine the cause of death, manner of death.
Also, what an autopsy.
So autopsy is an examination of the person who's died. There's two major components to the autopsy. The first component is the external examination. The external examination is very similar to the type of examination that we get when we go to the doctor and people. We get our height and weight taken, the doctor examines our external body, that's what the pathologist does. And then in an autopsy, there's also an internal. And with the internal examination, the body is cut in such a manner as to remove the organs that are in the body cavities to evaluate those organs. And then, like I said, the purpose of doing the external and internal is to determine the cause of death, then a manner.
And when you do an autopsy, what sort of things are you looking for that can tell you all? I realize that's the longest one.
Yeah, sure. Briefly, so to even begin an autopsy, we begin with information about the death, the circumstances. And that is the same as when you go to the doctor. We have to tell the doctor why we're there. Certain symptoms, there's a reason to be there. And that's the same with an autopsy. There's always some several circumstances are obvious in terms of the causes that we know. So it's kind of obvious they've died. And in that instance, autopsy documents the wounds, provides vital information. Bullet, for instance, in some instances, the person may die in bed, and we get information from family members about their history, and then that may give us clues. So we always have to start with some pieces of information concerning circumstances.
And is looking at someone's medical history or before we get off on to see what sort of book they were in.
That's correct.
Moving to this specific case involving 20-year-old Clinton Simon. After remains were found in this case, you recall being consulted by members of the district?
Yes, they did.
Okay. And did they come and meet you and photograph what they wanted?
Yes.
And then, are you aware of those names?
Yes, correct.
After the FBI was done, were the names sent to your office?
Yes, following the FBI examination of this child, I did receive those skeletal remains, and my examination was limited because the FBI was primarily involved as anthropologists, and I'm not very so my involvement in terms of evaluating the skeletal remains was inventorying the bones that we received.
Now, in a situation where the remains are, would you be able to?
No, not in the sense of obviously what I've just described to you as a complete autopsy on an individual who, let's say, is an intact body. So when there's only bones, it's going to be very limited ability to be able to provide enough information to say how a person has died.
And so is it normal in a situation where the remains are basically bones for a forensic anthropologist?
Yes.
I would like to talk to you about one specific potential cause of death, and that is what is commonly known as sudden infant death syndrome, or SIDS. What is the medical term?
So SIDS is sudden infant death syndrome. That's the acronym for SIDS. And SIDS is actually a definition of death. It's not anything that one finds in a child. So it's a very strict definition. SIS is defined as a death in a child who is 1 year old or less, whereby autopsy doesn't identify any specific cause of death. The autopsy doesn't identify an infectious disease process or trauma. So we call these negative autopsies. And so the autopsy is negative. In addition to that, the definition of CS also requires that the investigative information doesn't reveal any suspicious circumstances surrounding the death, or the investigation doesn't reveal any, for instance, in a sleep environment, not in the same that causes a child to asphyxiate or suffer. So it's very strictly defined as being a negative autopsy in a certain age when no suspicious. So, just to go a little bit from Lori skeletal domain, in this specific case, you were not able to perform each of your duties. That's and in this case, this wasn't just remain found lying out somewhere. They had actually been in the landfill and had damage done to them. Correct. Subjected to environmental damage as a result.
Good afternoon, Dr. Dillon. How are you?
I'm good.
So when you received the remains, you weren't able to conduct a normal autopsy. So you couldn't remove any of the organs, tissues, or anything like that. If I'm understanding correctly, did you receive any tissue samples, or was it just the bone?
So in the inventory, everything came to us from the GBI, packaged in bags and multiple bags. Mostly everything was bones. There was some small material that could not be definitively identified as organs or skin, but there was some degree of what we would identify as soft tissue.
So there was some soft tissue.
Yes.
Did you perform any tests?
I did not.
Were you asked to? Now, I was just curious. You said that in this particular case, when you say you perform external examination, I assume that means you would look at the file state or normal.
Yeah, normal autopsy, yes.
And that wasn't possible here, right?
That's correct.
And same thing with an internal examination. Again, see a normal biopsy.
Yes, you make the routine cuts to gain access to it.
And again, you weren't able to do that here, right? But you also mentioned the other thing a minute ago to Ms. Parker that you were told the circumstances surrounding that. I'm curious, were you given any of the circumstances surrounding that, or were you just given the bones and tissues?
No, I knew the circumstances surrounding the death. Our office was immediately informed of the death in October 2022. That the child had been missing for a period of time, and then the skeletal remains had been, or some of them, the whole body was never. Skeletal remains had been retrieved. I got the bones to look at. Basically, my looking at them was limited, and that was in March of 2022.
And you mentioned one thing in this part too, was talking about asphyxia or suffocation. I understand 20 months old is a bit old for SIDS, correct?
Correct.
But it's not too old to asphyxiate, correct?
So it depends on, asphyxia is a very broad term. So asphyxia can be choking on a foreign object, for instance, either a food object, toy or something like that, or child being intentionally suffocated. asphyxia is broad, and a 20-month-old is not too.
Well, then let's break it down. So what's the definition of asphyxia, so we can start?
Asphyxia basically means a lack of oxygen for a variety of different reasons. You may not get oxygen because of a certain position you're in, where your nose is not obstructed. You may not be able to get oxygen because something is obstructing your air. You choke on a piece of food or something. So it's very broad, meaning a lack of oxygen.
Basically, this means a lack of oxygen.
Correct.
It can be because choking, it could be for something lodging in the throat, it could be because somebody's strangling you, it could be for any of those reasons, but that's all asphyxia means, correct?
Yes.
So, and would it be, do you think it would be important for you to know that and you said the other thing you investigated when you were talking to Ms. Parker was about the sleeping. Would that be something you would need to know for the 20 months?
Well, not less important than 20-month-old. Is it around there as immobile in a sleeping environment as a younger infant?
Let's talk about that. At 20 months old, what is a normal 20-month-old's capability?
Generally 20 months old, they're able to walk. They're obviously able to go and turn from side to side. So those are things.
So they're ambulatory. They can move and they have their own mind about things, correct? So in this particular case, would it have been relevant to you to know if there was vomit in the playpen?
It would have been a piece of information if I had had a autopsy to perform on an intact body. The information about the scene itself was the information that we would see.
Was that information was passed along to you?
I'm not aware of that.
And that being said,
Everyone, thank you.
Where we were at is the team, and
yes,
that was what
number 18.
in the days of the defendant interview.
Yes, she was.
Before we get into that, I want to kind of keep this the first is a question about have you reviewed the indictment?
Yes, I have.
And have you seen that?
Yes, it does.
Are you aware of all those statements?
Yes.
And were they all made in check?
Yes, I am.
Was for every false statement?
Correct, yes.
There has been an exhibit admitted into evidence as states exhibit 62 circle game footage.
Yes, sir.
And which one of the two trims that footage?
It's her first trip.
Have you reviewed that footage?
Yes, I have.
And is it fair to say that it includes a bunch of?
Yes.
Is there a camera angle in which you can tell exactly what it is?
Yes, there is.
How is it that you can see exactly?
Yeah. So it faces, the camera angle faces the register as well as what is being run up by the cashier. So you're actually seeing the receipt as it's actually being run.
I'd like to explain for you the portion of State's Exhibit 63 that I think we're talking. So what I've done here is I've opened up the player that includes all this footage. It's a whole bunch of cameras. And here we pick the register camera that made it full screen.
Yes.
So sort of an overhead view of the register that she has at.
Correct.
Can you tell us where on the screen you can see what it is that she uses?
Yes.
Step down.
Yep. On the left.
Walk us through it.
List of what's occurring with the register as well as a quantity. So our targets are right here. We have a natural light 25-ounce can. Quantities changed to 2 cans, and then we have a cigarillos green quantity changed to 2, and then driver's license scanned transaction.
Can you tell us where we are?
So the timestamp that we're paused at right now is 10:29.
How many is it playing? Stop the player. Now, moving on to another miscellaneous. Do you remember hearing Officer Schenker of the crime team unit talking about the substance found?
Yes, I do.
Did you look back at the file to see whether you could figure anything out about what that was?
So in Shanker's testimony, and as previously mentioned, we believed it was like a rice cereal. That's also what Leilani told us it was.
And then you prepared an exhibit as this decision.
Yes.
What's the original what Mark states? Do you recognize those two items?
Yes, I do.
Can you describe those?
94A is going to be a PowerPoint of what 94B's printout is. It's a collection of photographs with the rice cereal.
So 94A is 94B is right?
Yes.
I would introduce this. No objection. I think I've got this one. Right, pardon me. What is this first slide?
So this is a photograph of the back of the Dodge Journey that was taken on 10/6, and it's kind of just displaying the rice cereal in the back of the vehicle.
Appears to be pretty evenly, widely distributed.
Yes, it is.
Moving to the next slide. What is this?
This is just a short clip of the interview we conducted on 10/5, where she's explaining what that is in the back of her vehicle.
Now, just to make sure we're clear here, the date stamp left corner says 10/6. Can you just, I'm not trying to catch you, I just don't want to.
Yeah, it's the 10/5 interview, but it's early in the morning, 10/6, so technically it's the next day.
Almost 5 minutes after.
Yes.
10-minute break. We'll see how this goes. All right. So, ladies and gentlemen, no research, don't discuss case, and we're going to take a quick break. All right, ladies and gentlemen, please have a seat. We'll take a 5-10 minute break. All right.
Layers of the rice cereal, like baby rice cereal.
Moving on to the next slide, what is this?
This is just a more clear view that Officer Shanker the photograph that he took that night. And again, you're seeing the bar area and those two images of rice cereal, or two containers of rice cereal.
Next slide.
Correct.
And then the final slide.
This is just a Google image of what we were previously looking at.
Cereal for baby.
Yes.
So those two canisters were out there to keep the police first.
Correct.
And the defendant told you she took it inside.
Yes. Yes.
Any reason, you know, that those things would be outside? No further questions. Let's talk about the final interview. What was that again?
Her final interview was on November 21st
And where was it?
at the FBI office.
By this time,
Yes, he had.
And at this point, have you taken out warrants, found this?
Yes, I did.
Now, were y'all bringing her in there in part at least?
Yes.
Did she have?
The Marines discovered it.
Did she know before?
She assumed so, yes.
Y'all, who did y'all correspond with?
Yeah, her mother, Billy Joe.
And she had been told that it was
I don't believe we told Billy either. I believe they both just assumed that's what was happening that day.
where in the FBI office?
It's in the interview room, which is in like the front corridor area.
Now, is it fair to say that this was the first thing that she was not?
Yes. Yes, she was.
Given that you were outside advisor,
Yes.
did you advise her?
Yes, there's a form that we read to her, and we provided her with one to read as well.
Did she indicate to you that she understood all those rights?
Yes, she did.
Did she have any questions?
I don't believe she did, no.
And did you all ask for? Yes.
Yes.
Did she do that?
Yes, she did.
And was that an agreement memorialized on?
Yes.
Did she also memorialize her?
Yes.
When to approach? You recognize that?
Yes, I do.
You tell us what it is.
It is the FBI's template format for advice of rights. This is the document that I believe Agent Sullivan mentioned and explained prior.
You guys,
Yes,
how many of these is? I got real quick. I think it's the. Okay. Now, how long roughly was this interview in this?
almost 3 hours.
Like, was it?
No.
You didn't like something about it?
Yes, it did.
Eventually, it's going to be.
Yes.
If we prepared, yes, excerpts for this interview.
Yes.
And do those excerpts capture essentially what her story was?
Yes, it does.
And then to approach it. You ready to have that?
Yes, I do. It is a collection of the November 21st interview. 16.
Series of excerpts.
Yes.
You remember how many times?
There's 3.
And what you just kind of described those.
Yeah, so the first one is going to be kind of the initial conversation we had about cocaine. In this video, you will see Leilani telling us what cocaine does to her, what she's learned, through some of the counseling that she's had. She'll talk about how she's, experienced illusions, change in emotions while high on cocaine, and we're discussing whether or not that's what happened. The second clip is Leilani changing the trash story. She's talking about how there's now 2 bags of trash, and we're discussing whether or not Quentin was in one of those bags of trash. The third clip is us confronting Leilani on how many stories she's told us over the last 2 months and why she told these stories.
What was kind of the core claim on this day? what she remembered the Azalea trip.
The majority of the time, she's saying that she doesn't remember the Azalea trip. She only remembers returning home, specifically going over the railroad tracks right before she gets her residence. There's also other times where she says specifically she was throwing away just trash and pasta while at Azalea.
Did this claim that she was making when she was driving sometime? This to you?
Yes, in the same manner.
The clips on this is fairly accurately portions.
Yes, they do.
Other than it being extras, has it been altered?
Yeah.
You're gonna introduce this.
Yes. Okay, we are back on the record.
Okay.
All right, thank you, Mr. Hilliard. State Exhibit 81.
All right, where are you?
I'm right next to Agent Solomon, to her right, but I am off camera.
This is first, yes. I know
Will it come back later, or is it just like? So not a dream where it were. So they can hide something. How we can happen. Exactly, it's pretty, and it's learn to try to see, you know, all that, so I'm grateful. Basically, been attached to your family and and I'm just trying to know what's another great position of is I'm wondering if you have some current stories, you know, I'm sure you know, and we'll see how they treated you for the last and without your story anywhere.
So when did you remember? Let's
She said the last thing that she remembered was looking at Quinn and then driving back from Zil.
Looking at what after the park.
Yes, and then blacking out and then coming back to it as she's coming back from Zil.
And what would you say? What caused her to start falling?
Hitting the railroad tracks.
So, fair to say she's claiming something like a 2-hour plus.
Yeah, she would have gone back from her grade shortly after 11, and then she gets back from Azalea around 1:30. So yes.
And is it fair to say that
Yes.
it's like the times of the promise.
Yes, it is.
This next clip. What is this?
So this is us touching on her previous statement back on 10/12, where she's describing her existence, how she threw away the trash, and we're asking her to revisit that memory that she's had. And she's telling us that there's 2 trash bags, and then apparently has the zip.
And does she? And this book is later in time.
Yes.
This is previous. Just told you about the story.
Correct.
Just story was saying
Did we ever hear that? She said there was a trash bag.
Yes,
And then you said, is that what was?
yes,
And at that point, she said, well, there were 2 trash bags.
yes,
And did we hear from you? Did you use a trash bag?
yes, I did.
And by that, did you mean, did you use the trash bag?
Yes.
And what's her answer to that? I don't remember.
Sure.
In other words, she didn't say, oh, hold on, I did this.
She did not say that.
It is about 3. This, do you remember what it is?
So we're challenging her on her community stories throughout the last 2 months and why she said these stories to us that she didn't have in memory, why she constantly changed, what happened that night, who went out to Azalea. It's kind of just our last practice trying to find out what it is.
well, why did she tell us? Tell us. So I understand Stephen makes remember seeing the trash bag looking into it. Student actually look into it. They were pretty they were wrapping up. And they were really, do you remember Andy? You know this was. Why did you tell us all the story about just all these stories? He was sorry.
That's what she.
What was she?
She's saying that every time that she liked was her sharing her weight.
Or she wasn't.
Yes.
She was describing the word.
Yes. Yeah, she said she found it in her vehicle. That's in the vehicle.
And did she describe her story?
Yes.
Now, I want to just ask you stories that you talked about it.
Yes, it is.
Did this story, was she about?
Yes, it did.
Where she?
Yes. Yes. Yes.
Did it include details such as story about graduation, especially this time. Specifically,
Yes.
it's how long?
Yes.
How long? She first.
Yes.
In addition to that,
Yes.
estimate.
Yes.
You had either adopted those.
Correct.
Did any of your business? Yeah. This. Was she asked at some point by you?
Yes.
She,
She did.
was she asked? Do you think
Yes. That's correct.
was she at some point, especially if it's that you part of your child for words to them?
Yes, she said that.
And is it fair to say that
She did not.
and separately, the special education office
She said that.
is she also
She. I know. This is still very simple.
Thank you. Reflect that attorneys are present, the assignment is with other counsel. And so, Mr. Hilliard, is there any examination? Okay, is the state ready to proceed as well?
Yes, sir.
Please bring in jurors. Appears that everyone is not ready. So the jurors who are present, if you'll go back to the deliberation room, that's fine. On second thoughts, it appears that things are working out. All right, excellent. Yeah, I'm gonna change your word. I can tell that was gonna be a thing. Everybody, please have a seat. Okay. So, ladies and gentlemen, we're gonna move now to further testimony. Okay, and no one discussed the case or did any research. Hey, this is weird.
To the beginning for that piece. Picked up the wrong. So you arrived on scene at 10:30 on October 5th, correct?
No, after 12.
After 12? how long were you on scene on October?
On scene, probably about an hour.
And at what point in time did you take Miss Simon, Mr. Youngkin, and Mr. Simon over to the precinct?
I asked one of the patrol officers and some of the detective staff and transported probably within an hour.
So probably around 1 o'clock. Just kind of get a general idea.
Yes,
So October 5th, around 1 o'clock, all three of them went over to, yes, police.
headquarters.
And how long were they there on October 5th?
Until about 2 a.m. the following day.
So about 13.
Yes, sir.
And over the course of the trial, we've seen a number of interviews during this time, correct?
Yes, sir.
And during that time, you were also speaking with, I'm going to assume, I'm not trying to put words in your mouth, speaking with Miss Simon, Mr. Youngkin, and Mr. Simon, as well as others at the time. So those were the three, right?
That our team spoke with you.
So that was 13 hours from the 5th to the 6th. When did you next speak with Miss Simon or have your team speak with Miss Simon?
We were in communication with her for probably the next 2 weeks, almost every day.
Okay. When you say ran communication, I guess that's phone calls.
Yes, sir.
And when was the next, yes, in-person interview?
October 8th,
How long was that?
almost 2 hours.
And that was at CCP as well?
No, that was the FBI office.
And when was the next one after?
October 12th.
How long was that one?
That was almost 2 hours as well, and that was at the FBI office.
And during this time frame too, this is a phone call. You still having phone calls during the student time?
Yes, sir.
It's 13 hours on the 5th, 2 hours on the 8th, 2 hours on the 12th. When exactly were those calls? Video and audio.
What part of it?
The actual time they were in the hotel room and y'all were video.
The 8th and 9th.
That was October 8th to 9th, correct?
Yes, sir.
And during the same time frame, you were wiretapping Danny Young's phone from, I think, around the same time, October 8th or 9th, for about 6 minutes, right?
Yes.
Intercepting all the phone traffic.
Yes.
Just after the matter, the rough estimate is, even after you arrested Simon, you still intercepted this phone call, correct?
Yes.
And that was at least, generally speaking, between October 8th, 2022 to December, correct?
Yes.
So that's going on at the same time the other interviews, right?
Yes.
So October 12th, I'm sorry, was the next in-person interview. When was the next interview that your team did with Simon?
After October 12th, October 31st.
Right. How long was that one?
That was at the FBI office, and I believe that one was also 2 hours.
And the next one after that?
Would be her final interview when she was.
What day was that?
That was on November 21st.
That one was how long?
3 hours.
And so from October 5th to November 21st, were you still in constant contact with her?
The team was.
The team. By the team, you mean yourself, Agent Solomon, Agent Schultz, anyone who you delegated, right?
Yes.
Now, and you said that on, I think it was November 21st, you expected to be arrested, but you came, correct?
Yes.
You asked her to come in, correct?
Yes.
And she came in, correct?
Yes.
Now, we've seen some of the excerpts here that you put up with. Now, let me ask you this. What interrogation technique were we just using?
but I don't have a name for the technique for having a conversation.
Well, you said you don't have a name for it, but you've gone to the academy, correct?
Yeah.
You were trained in interrogation, correct?
Yes.
What interrogation technique?
I don't have the name for the techniques. My way of doing it is just making sure I have the full story. And if I don't understand anything in somebody's story, I just keep asking questions until I do.
So in this particular technique, which we just witnessed, and we've seen the entire time, is it safe to say that you're putting individual stressors on review something?
In which interview?
All of them.
It depends on what you would say is a stressor. We're talking about her dead child.
Okay, well, and that's my follow-up question. Wouldn't you think speaking about that would be a stressor?
Yes.
And wouldn't you think that speaking about that would provoke?
Yes.
And you seem to have had opinions about that emotional response, but what have you been trained that is the appropriate response? Have a level?
Can you restate the question?
I can. So if you are overly hysterical, then you're overly hysterical. If you're not hysterical enough, then you're not hysterical. How do you gauge the appropriate response level to your question for you to be satisfied? What's the right answer? What could ever be the right answer?
For what appropriate reaction she had?
Yes.
I'm basing that on previous interviews I've done with families that have lost their children.
Right. But every individual is different, right?
Yes, sir.
So in this particular case, a number of times Mr. Green was asking questions and he said, careful. And how do you make that determination? What is the appropriate objective standard by which you
I believe I focused on the October 5th interview when she would do the screaming and yelling portion.
And that was when you made your decision, correct?
Decision about what?
As to how and where you were going to focus your attention this past week.
No.
Then when did you decide that Ms. Simon was?
She was our prime suspect, you mean?
I said, when did you decide that she wasn't? You said you didn't do it on October 5th. So we're saying she wasn't your prime suspect on October 5th?
No, we looked at all three of the adults in the residence as possible suspects.
So that being said, you looked at all three of the adults. Did you ever look outside the residence as a possible suspect?
Yes.
And what did you do to pursue any of them?
Outside the residence? So we did a canvas, as we previously talked about. No leads came up about any suspicious persons around the residence. We set up the tip line that did not prove any other suspicious persons. We spoke with probably every single family member of this family in Savannah. None of those had any guesses on who it could be, including the three people that lived there.
And let me ask you this one. All of the interviews, she was free to walk away or not.
Until the final one.
The final one was a little bit different, correct? Did you already have?
Yes.
So and even knowing that, she still came back, right?
Yes.
Now, Mr. Dean asked you a question about whether or not she denied it, but not denying it, also not admitting it.
No.
Not the same thing.
No.
So, and my recollection was, I don't think she's ever any bit of harm in putting it. Now, in the last interview, at that point in time, had you ever determined manner of cause of death?
I have an opinion on that.
I'll ask you your opinion. Has a doctor made a medical determination as to manner of death?
No, due to the remains, we were unable to find them.
That's no. Okay. And that being said, when you were interviewing Ms. Simon, particularly, you focus on a lot of things. She never said that she killed Quentin.
She never said that she disclosed the physical.
She said she did not remember.
Now, you said you had an opinion, but opinions are just that. They're not based, they're just your opinion, right? I have opinions, you have opinions. People have opinions. Right?
Yes.
And opinions are not evidence.
Yep.
Okay.
State, they call it state police.
May we have Your Honor, subject to verifying that all of the evidence that we've offered has been formally introduced, the state rests.
And so with that, jurors, I'm going to ask you to return to the deliberation room at this point. Thank you, Deputy. Everyone may have to.
Exhibits, and we should have exhibits 1 through 94, 94 is A and B, in evidence with the exception of a, sorry. What I'm saying was we should have, the state should have exhibits 1 through 94, which is an A and B exhibit in evidence with the exception of state's exhibit 80.
So 1 through 94 A and B, but not 83.
Not 83. We just wanted to verify.
Mr. That's what
Thank you very much.
Thank you, Ms. Parker. And then, is there any motion by the state? These are the things. Just a moment.
Your Honor, at this time, I'm going to focus my argument as to a motion for direct verdict. Just so we're all on the same page, I'm focusing on 1, 2, 3, 4. And I'm going to take them kind of in separate practice and all together. With respect to counts 1, 2, and 3, that allege that Leilani Simon committed malice murder and felony murder. Quentin Simon, the defendant moves for a directed verdict of acquittal. First, there's no direct evidence to support these claims. The state has presented theories and its conclusions, but has presented no direct evidence that Leilani Simon committed these crimes the way they're charged, counts 1, 2, 3 in the indictment. I think the medical examiner's testimony is significant. She expressed no opinion about the manner of death, cause of death, the time of death, and even as an expert in her field, couldn't even express an opinion that Quentin Simon died as a result of the commission of these crimes. That leaves us with circumstantial evidence in Georgia, and I'm quoting Official Code of Georgia 24-14-6, quote, to warrant a conviction on circumstantial evidence, the proved facts shall not only be consistent with the hypothesis of guilt, but shall exclude every other reasonable hypothesis, save that of the guilt of the accused. With respect to the circumstantial evidence argument connected to the murder claims, again, the medical examiner's testimony is extremely significant because what it presents and what it leaves out raises lots of hypotheses as to what happened to Quentin Simon, and does not only establish the guilt of Leilani Simon as alleged in the first 3 counts of this claim. With respect to count 4, that alleges concealing the death of another. Concealing a death is against the law in accordance with Official Code of Georgia 16-10-31, which provides that a person is guilty of this offense, and I'm paraphrasing the statute, when a person conceals the death of any other person and does so to hinder a discovery whether or not such person was unlawfully killed. In this instance, the medical examiner's testimony again failed to establish that Quentin Simon's death was the result of any unlawful act. Basically, all 4 counts of this indictment, I should say, is grounded in a bunch of theories and the state's speculation and conclusions. With respect to that, in suggested pattern jury instruction 1.20.20, law provides that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a suspicion or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. At this point, the state's evidence is grounded in speculation and grave suspicion, but not on facts, not evidence. On behalf of Leilani Simon, we move for a directed verdict of acquittal with respect to counts 1, 2, 3, and 4 of the indictment.
Thank you, of course. Mr. Dean.
Your Honor, I'll be brief. We've presented sufficient evidence for the jury to find based on those circumstances. The defendant is guilty of all of these counts. The Wyatt case is clear that when we allege such as narrow down and certain other facts, those become material allegations. And I think think that this person's understanding of the medical testimony is exactly right. It does not support a directive verdict on any of these counts. In fact, it was offered to prove the material issue that certain facts we've said that we might this the manner of it, and that was a point of so we proven that circumstantial evidence exclude all reasonable evidence. There was no medical, there was no accident. About that. With any type of accident. There are only so many ways to we excluded all of them, but in potential and concealing that requires that you conceal the such that it occurs such that you have the investigation. I don't know whether there's ever been more scrutiny body of evidence that supported the weight of the judge. I could go on.
Thank you. I am going to find that based on the argument made by the state, the court finds that there is sufficient evidence that has been presented for the jury for the charges in the indictment. The motion for the court. Are there any other motions? So, I'm going to have Ms. Simon to come up to the witness stand. Before going to the witness stand, it will be.
The evidence you're showing to the court, it is pending, shall be the truth, the whole truth, and nothing but the truth. So help God.
Ms. Simon, please have a seat on the witness stand, please. All right. I'm going to start out with Ms. Simon. Ms. Simon, please state your full name.
Leilani Simon.
Okay. And you're doing the right thing, just talking to the microphone so the court reporter can get it. I heard me give that instruction a couple of times. Do you understand that you have a right to testify? And that if you want to testify, no one can prevent you from doing so?
Yes.
Do you also understand that no one can make you testify? No one can compel you to testify. Do you understand that as well?
Yes.
And you have the right not to testify if you don't want to. Do you understand that? Do you understand that not your lawyer, but you personally are the one who decides whether or not you will testify?
Yes.
Do you understand that if you do not testify, that upon proper request by you, the court will instruct the jury that your decision cannot be used against you? Yes. In fact, the court will instruct if you decide not to testify. You understand that?
Yes.
Okay. You understand that if you choose to testify, you will be examined by your counsel and cross-examined by the assistant district attorneys in AUSA. Do you feel a need to have any additional time to consider whether or not you will testify? Okay. Do you need any time to talk with him in private about this? And so do you personally wish to testify or not? And with that, I find that the defendant, Leilani Simon, has decided not to testify with a complete understanding of her rights. Before you step off the stand, are there any further questions?
Of course, you to testify.
No, sir.
Your choice is made.
Yes, sir.
You have adequate time to
What is it?
just have to make sure.
Sorry, you may step in. Let the record reflect that you can do your decision. Sometimes to speak with me.
I'm going to go back. A couple of questions. What happens next?
Let's do that. It's about potential. I can't tell the time by that far. It is 3:20. Okay. So let's step off until about 3:30. So, okay. Great. Okay. Get this started. Okay. So we're back on the record at SPCR 22-03364J6. Ms. Simon is present with the council, of the state, present as well, Ms. Detective Lincolns. Is there anything that we need to pick up before we bring to the record? Yes. Yes. That was just a simple book. Thank you. Bring the record. Thank you, Deputy Smith.
All right, ladies and gentlemen, please have a seat.
There were no discussions about the case or research. There's Mr. Hilliard.
Thanks, Brad.
And with that, ladies and gentlemen, we are going to release you for the evening. There are some legal matters that are outside of the presence of the jury. I'm going to have you come back tomorrow at 10 o'clock a.m. Please continue to follow the court's instructions. Do not discuss the case. Don't let anyone discuss the case with you. Don't watch television shows. Do not do any separate research. Okay. All right. Very well. Thank you very much. Please have a seat. Thank you. Thank you. Okay. So I've received, of course, the request to charge statement, and I've had an opportunity to review folks' debts and do we have a copy? Okay. So I'll have set for you to take a look at, go through those, and see where we stand. I'm having the jurors return tomorrow at 10 o'clock, just in case we need to take up anything earlier than that. I expect us to begin. And it may very well be, there are a couple of the counts. We had some issues with it coming up with what the charge should be. And so that may take some thought. I certainly would like to hear what you have to say. Let's get those requests charged to you in just a minute or two, and then we can go through one on one. All right, with that, we're in brief recess. And a stack of jury charges of what I need. Right. Okay.
and we need to sign this. Charges if they'll put together now, pages 1 through 22. And let's just go in order. Page 2, we have the charge regarding the indictment issue and pleading not guilty, presumption of innocence, burden of proof, reasonable doubt. All of that is pretty standard. Is there anything with any of those? Grave suspicion. No, let's go. Let's take the objections as we go.
I would object to grave suspicion. As far as charges, I don't even know why it's still in there, because the back charge says, hey, this is totally unnecessary, like detailed and comprehensive presumption of innocence. That's supported by recent, I mean, a number of cases. The reason is jury instructions. I think what that charge meaning is presumption. I just think it's totally confusing. I hate it, but visceral hatred raises suspicion. And we would ask. One thing that's nice about this case is it's pretty clear that apparently it should never be used in discretion. That's your position.
So, Mr. Dean, I ran through the first charges, came to grave suspicion and stuff, because I imagine that you would have a problem with that. Mr. Hilliard? Mr. Perks?
I think grave suspicion is important.
I guess
I don't think it's error for you to give that charge.
I don't believe it's error. I'm going to take a look at that again, but my thought is to leave it out. But, okay, so we'll start by that. Jury judges the facts, evidence, direct and circumstantial evidence, credibility of witnesses, expert witness, witness attack, page 6. Is there any issue with this chart?
We were talking about this prior to it. I don't have a problem with drawing, and I think you, I think it just honestly. Last trial we had an issue with. We got to pay it. Now one. I think in this particular case, one of them.
Mr. Diener, market withdrawn.
Yeah, for what it's worth, I agree, Your Honor. I also agree, I would make the same basis. I just don't think we have.
So witness reported is withdrawn, witness impeached. Prior statements.
That's the reason.
Yes. A lot of visceral hate. Okay, so prior statements remain immunity or leniency granted. We did have immunity granted.
Yes.
Okay. Withdrawn. Single witness corroboration. Defendant's choice not to testify. Statements of defendant. Circumstances of statements of the defendant, voluntariness defined, those will remain. Circumstances of the statements, etc. Any issue there? Burden of proof as to voluntariness. Statement of defendant made on November 21, 2022.
I understand it was all the previous statements were voluntarily made. November 21st statement, which is why I think it's.
Thank you.
Everything with voluntariness included in addition to the additional that comes after the statement. I would like to talk
To me, I think page 8 was good, because the jury does have to find voluntariness on the statements. I think the only suggestion is page statement. I think the bill on lines 4 and 5 is if the statements. I think part of this good. Basically.
So your suggestion is to take that
Take that
out. If the statement was given in custody, just take it out.
Just take that out and say maybe so. Yes. Yes.
departments pay for voluntary and.
Right, this is exactly, this is like exactly. Instructions.
But also movement, everything.
I don't have this.
Moving on to constitutional rights. Any issue there?
In the if part, at the outset, it's sort of like the same deal as the last part. Yeah, maybe it's to say because the alleged, because the alleged members of the state.
Simpler, how about if the statement was made?
Ms. Parker, could have been that microphone.
To simplify that, how about if the statement was made public? Because we're not really asking them to find it.
Yeah, I'm not asking you, but no, this is only a place.
That's the only.
Just that.
Moving to page 10, decision initiating further conversation.
I don't think that this instruction should be given because nothing was introduced. Indication. Some of those earlier with indications of various rights or found they were legally ineffectual prior to trial. Those were all reacted at the request of the defense. Child property. But none of it came. I think the instruction action.
There are defendants initiating further conversation. That charge is withdrawn over burden of proof as to rights. Okay. Conditions proceeding to consideration of statement. Prior difficulty.
And conditions precedent for consideration of statement. There's that bit in there. The rights warning being a condition precedent. As we've been talking about review, so I don't know, I can't think of the top. Maybe it says if you find, as mentioned, statements or voluntary and that all of the warnings listed that's to November 21st. There's got to be some way that. Okay, yeah, okay, let's get it. That all warnings instead of defense constitutional rights were given to acquire. Because I think it'll be pretty clear at this point when it's required.
Are you okay with that, Michelle?
I am joking. When we're speaking of first thing, we all agree. As long as we're finding some way to table it, we don't.
That is the most important thing.
And then that same point, if you fail to it's where required.
We'll make those changes. Moving in to the next charge, prior difficulties between parties.
No issue with that.
I would object to that. I'm willing this, I mean, what was the part? That's okay with private. Incident stuff. That's not charging me.
I think the difficulty here goes back to what we talked about earlier. There were witnesses that testified about what they observed as the interactions between the defendant and Quentin. And this does take some Caroline to speak.
I think that George has to be in here. I mean, typically, cases comes up with this case. Definition. The incidents that's really related is far higher. I worry about charges.
I'm going to include the trial. Identification purposes. I don't think there is an issue with this one. DNA. Any issue with that?
No issue.
Definition of crime. Intent. No presumption of criminal intent. Presumptions and inferences. We are party to a crime here.
I'm sorry. I hate to bring it up. The risk is 13. You know, spell check got you there.
And that's, I read it in inferences, I looked at it, yeah.
There are some references. Reference to the B is.
Yes. Thank you. I'm sorry.
She said it doesn't matter what it's.
Okay. Anything else up to, okay, we're now on parties to crime. I think this is your year as well. Okay. Yeah. Let me hear from the state.
I'd like to just
Party to crime. Why?
I don't think we're going to push. I allows for people. It allows for people who perhaps are able to involved in some capacity. I like it.
Let me take a look at that. Go ahead, Mr. D.
No one else is charged. Things in time period. So it's just completely okay. We object.
To me, it's just a fundamental expression of fear. What is required to I don't know that it's
I'll take it under advisement.
Thank you.
Thank you. Guilt by mere presence. Mr. Hilliard. Mr. Dean, Mr. Simon here. Guilt by mere association. Venue. It is a pattern charge. Malice murder. Malice motive. Okay, felony murder. That's one that we want to make sure, I want to make sure is felony murder, conviction in felony murder. Absolutely. That's essentially the pattern. The felony murder.
These are from the latest news.
Right. Okay. That wasn't it. The aggravated assault was the offensive weapon. So let me go back. Felony murder. Once I read it, I had a circle for some reason. Pattern, conviction, and felony murder. Any issues with that? Concealing death. Civil assault generally. Yeah, it's by way of explanation. The aggravated assault wasn't offensive.
The only suggestion I think we've got budget that actually if that is that's the I mean, and that's not necessary that we take approved. You're not ready.
The indictment.
Yes.
And if it's a weapon, is any object that does cause, right?
You say cause.
Causes. Causes or actually does. What would be that? Okay. All right, determining if weapon is offensive. That charge. Okay. Cruelty to children in the first degree. That's also statute. Any issue with cruelty to children in the first degree? Voluntary intoxication, non-defense.
And see that item 2, cruel and excessive. 3 is cruel and excessive. I know it's charged as it's charged with cruel and excessive. There's a it's not necessarily if we don't choose that word, I think that's
judges. I read about that. Certain routes to be. Rather than change.
These laws, but these law also said in the simplest way not to have it like jury, it's just. Do you hear anything first?
My inclination at this point is to have number 2 read pool for excessive deductible moving on then to voluntary intoxication of the defendants.
Object. Fine. Well,
I believe
I requested it because no jury instruction is based on the evidence. It's an accurate statement. Perhaps.
false reports, and we will make change there. She will make those.
it does say, it says misdemeanor in there. I don't think the jury's to know the distinction with respect.
Just making that whole is in blah, blah, blah.
Yeah. So that's hard to go in without the last phrase is guilty of making a false statement. Word generally, the unanimous verdict are court has an interest in sympathy, responsibility, protection, deliberation, fair use of technology, required to do. So during that period, page 3, great decision, Mr. Hilliard, would like that to remain. They're inclined to allow it to remain. Although I agree with you, it's not necessary. The witness attack on page 6, as well as witness support on page 6. Page 7, community or agency grant witness will be given. Page 8, statements of defendant. On page 8, really page 9, will be adjusted to reflect the difference between November 21st statement being in custody and the other statements were not in custody. Constitutional law. We need to change that. Defendant initiating further conversation, that will not be given. Conditions, proceeding to consideration of statement, will reflect as to the November 21st, 2024 statement. Difficulty will be given over objection. Page 13, inferences will be corrected. Page 14, parties to a crime, or parties to crime. The state very much wants that there, the defense does not want that. Right there, under that. Okay. Thank you, Mr. Dean. So, parties to crime will not be given. And then, aggravated assault with an offensive weapon.
Which page?
I'm sorry, page 8 will be the last one will be changed to an offensive weapon is any object that causes death or serious bodily injury if used against them. Also on page 18, cruelty to children in the first degree. The number 2 enumeration is going to be cruel or excessive. Otherwise, it remains the same. Voluntary intoxication will be given over objection. False report of a crime, also page 19, will be given except the last part of that charge is guilty of a misdemeanor will be eliminated. And everything else.
When these charges are actually given to the jury, and assuming we have objections in the court statute, both cannot say that record. Is the written charge that you actually get part of the trial record?
Yes. And I plan for the written charge to go.
The only reason I ask is I assumed it was part of the record, sure, because if it comes up here, the charge that was actually given, where you could reference, here's where it looks at, or here's where you can find it to see what we're talking about.
Anything else regarding the jury?
One thing that I did was this diagram is says it could be an but I think it needs to say it is condensed or in the alternative at the front end it should say the person commits the offense of making a false statement when she knowingly willfully
That last instruction makes it
Yes. Yeah.
more clear.
Okay, for that note, or anything else that you're finding here in your instructions. And of course, take a look at it. If anything else comes up, we can make change. We can discuss it and make changes. but we're gonna have the jury charge. We believe it's gonna go out to the
Can we get a copy? We have issues.
Did you just change the time?
No, I'm still open 9:30. The jury's still back.
Yeah, we'll do 9 o'clock.
I don't care either way.
I like 9:32, but we'll do that.
I gotta do it. I think we have it tonight.
Yeah, we'll have it tonight. And if there's anything else that we need to do, we can. Is there anything else tonight? Thank you.